Antitrust Law in Space, Sports, and HRM, touching bases on practicing antitrust law. 30 years ago, May 24th, 1995, the U.S. 10th Circuit Court of Appeals issued its ruling in the antitrust law case Roman v. Cessna Boeing. Cessna Boeing lost, Roman won. I was Roman's attorney, lead counsel, and I was prevailing appellate attorney in that case. The citation is Roman v. Cessna Boeing, 55 F. 3rd, 542, 10th Circuit, 1995. I'm going to tell you about the judges. It's a panel of judges. One member of that panel of judges was Arthur L. Alarcon. Alarcon was described by a later Chief Circuit Judge as the gold standard in judicial excellence. I think that's true. When he was a district court judge, before becoming a fellow appellate court judge, Judge Alarcon presided over many famous trials, including that of Sirhan, Robert F. Kennedy Sr.'s assassin. Alarcon was a U.S. Army sergeant who fought in Europe in World War II. He was awarded the Bronze Star and Purple Heart. The member of that 10th Circuit panel was Chief Judge Stephanie Culp Seymour. Seymour was the first woman Chief Judge of the 10th Circuit. She was one of only 23 women out of 550 students to graduate from Harvard Law School in 1965. Judge Henry had previously been Attorney General for the state of Oklahoma and the Dean of the Oklahoma City University School of Law. He'd only been a judge on 10th Circuit Court of Appeals about 1 year when I appeared before him. But top judge, my client and I were very lucky to have this case before brilliant and experienced judges. Roman gave me permission to relate some portions of the story implied, but not explicitly in the official record. That was nearly 30 years ago, but I'm not saying much that's not on the public record, though. Here's a verbatim quote from the 10th Circuit ruling. The complaint alleges that defendants are in the labor market for airplane engineers. That was a term of art that was used at the time. That plaintiff, Robert Roman, was an airplane engineer and part of that labor market. That defendants have conspired to avoid competition in that market in violation of the antitrust laws by horizontally dividing the market as between them by not hiring each other's engineers, a no-switching, non-competition agreement, and alleges that as a direct and proximate cause of defendants' actions, plaintiff suffered damages to his business and property interests. The lower court federal district court judge disagreed. He said this was not an antitrust law case and dismissed it. I appealed to the 10th Circuit. After exchanging legal briefs, the court scheduled the case for oral argument. I had to travel to Denver, where the 10th Circuit meets. Unlike a trial that might take days or weeks, in a hearing before the panel of the Court of Appeals, I was given no more than 15 minutes for oral argument. Opposing counsel, very capable lawyer, took all of her 15 minutes. I took 7 minutes and asked to reserve the rest of my time. After opposing counsel finished, I took 3 more minutes. Now, reasonable minds may differ, but as a rule of thumb in appearing before appellate courts, In oral argument, less is more. I took only 2/3 of my allotted time, 10 of my 15 minutes. My view in practicing oral argument and appellate law is to know your case cold, argue it, then stop talking. The judges understand the law, especially top judges like these three. They will ask questions if they have any. The judges voted unanimously in favor of my client. This was an antitrust law case. In pleadings, Cessna Boeing violated America's antitrust laws. The case was settled after this decision, so as of now, there's no more claim. However, to this day, Roman v. Cessna is cited in articles and cases about HR law and antitrust law and many other arenas. I didn't stop practicing antitrust law. When I was in law school, I was taught that most law practiced in the USA is private law. A lawyer representing a client contacts a party explaining why they are going to be sued. The other party responds. They either deny all claims and say go ahead and sue, or, much more commonly, they want to resolve the matter without going to court, and that's what I did most of the time. Now, in a few forthcoming posts, I'm going to talk about antitrust law in a number of contexts. For example, Donald Trump won an antitrust lawsuit against the National Football League when he owned a team in a competing league, the United States Football League. I'll let you know about that. Now, some mistakenly say that he lost because he didn't win much money. He won on the legal issues. It was held in federal court that the NFL violated America's antitrust laws. And I doubt very much that Donald Trump has forgotten that. Don't be surprised if the NFL has antitrust issues. In fact, if the USA sues the NFL may go out of business as it presently exists. Antitrust law can also be used in human resource management cases. It has been used, and I'll tell you about some of those. It can also be used in cases about space travel, specifically about the legal entities that make space travel possible. I had a paper published about that back in the 1990s. Don't be surprised if there's some changes in space travel entities before Donald Trump leaves office as president. In later posts, I'll share some basics about antitrust law for those who don't know much about it. I've always found it quite interesting. It's economics and law. Maybe some of you will find it interesting too.